minutes behind. Thank you so much for joining us. Laura Dinon from Plunkett Cooney is here this morning to talk to us on employee handbooks. She has met with us many years in the past and provides valuable information to our group each year, and we're appreciative of her being here every year to help us out. So I'm going to go ahead and hand it over to Laura, and if there's any questions, please go ahead and type those into the chat and we'll make sure she gets those. Thank you again. Welcome, Laura.
Thanks. Sorry, everyone, for getting here late. I'm going to do general overview of handbooks and the types of policies and how you should organize them, and then address some issues that have cropped up over the last couple of years that probably you need to rethink. And as always, you feel free to ask me questions as we go along, put them in the chat, and Jamie, if you can watch the chat and tell me if I need to address something. Yeah. So just a refresher, you guys probably know this, but the purpose of a handbook, there are multiple purposes. It's a great resource to give your employees to go to first before they have to come to you. It can answer a lot of their questions, explicitly lay out your practices, policies, and what your expectations for them are. It gives you an avenue to advise your employees, again, of your expectations. And one of the biggest reasons to have a good handbook is that it protects you from liability. If a government agency comes in to investigate, which they generally do based on employee complaints, and the most common one that lands on my desk is a discrimination complaint of some sort, and the EEOC is so responsive and receptive to an employer who I can send our first initial communication going through the handbook and saying that in 10 different places we say we don't discriminate, and so then the tag turns and they look to the other person to prove why you aren't following this policy. Like, they love to see that in writing. So for that reason alone, it's a really good reason to have a handbook.
Laura, they were just saying that you sound a little bit muffled, so do you want to come over here? Maybe it will.
Sure.
Yeah, that way it might be a better sound. Thanks.
Okay, sorry. So just a quick refresh for if I didn't come through clearly. Biggest reason to have a good handbook is to protect yourself if the government comes investigating. If you have policies that say you comply with the laws, the EEOC will take that, or the other government agencies will start with the premise that you complied with it. If they can prove you didn't, then you didn't. But if you have those, you have a leg up. The other thing to think about when you have handbooks is follow them. Train your managers on your policies, your doctors, whoever, and make sure you're following the policies that are in your handbook, and it'll be good for everyone. And that's the other thing about handbooks is you should customize them for your practice, because you want it to reflect what you actually do. It's great to have a handbook that says everything perfectly the way it should be, but if that's not what you're actually doing, it's really better to have it reflect what you're doing, as long as it's legal. But you want it to be personalized. You want to think through the way things work in your practice and make sure that it reflects that, because it doesn't really do anyone any good if you have these great policies that don't have any relation to the way you actually run your practice. So usually you have an introductory section. You can do a history, a welcome, introduction to the practice, glad we have you working here. We have this long history. These are our doctors, whatever it is. And then I like to call it general information or something like that. But this is the next section should be, the first thing they really are greeted with are all your legal policies, your non-discrimination, your ADA type policies, your I-9, GINA, compliance with all the federal and state laws. So you're upfront, again, this is what the EEOC wants to see if they come in, that you have these policies, you know them, and you're putting them forward for your employees. Some other things that go here that you might not know, and if I don't have I'm not going through every single policy because it would, I think they're common sense that most of them you probably already have, but if you have questions, and some of the ones that people may or may not have that are required by law is lactation accommodation, allowing nursing mothers to take time off of work to express milk. It's really bizarre, but it's actually it's required by the Fair Labor Standards Act. So it's just kind of weird how that snuck in there, but it's required for every employer, regardless of size. Then there's the Michigan Right to Know law, which allows employees to know what chemicals they might be exposed to in the workplace or hazardous materials. And that policy is required to be in your handbook by Michigan law. And then the Michigan Social Security privacy policy, which has been around for a long time, but again, is required to actually be in your handbook, is the one that says you're not going to use Social Security numbers for improper purposes. You can also include some business specific policies here. Certain, it's a fluid document. You don't have to organize it any particular way, but this is over the years, the way I found it seems to work best for ease of use and flow. You can put business specific policies here under general information. Things like if you have a non-compete or a confidentiality policy, a nepotism policy, like think through employer policies that are specific to your practice could go here also. Or you can separate all those out that are practice specific and call them, you'll see as we get through here, but you can have a section called employer responsibilities, and then you'll see I have one. A major section is usually employee responsibilities, where you tell them what they're supposed to be doing. So your HIPAA policy can go here because again, it's, I really like to include upfront all the legal requirements. And so some of these, you're also going to have a separate agreement that they sign off on and a separate policy, but you can reference it in here. Like if you have a complicated HIPAA policy, which a lot of medical practices do, you can pare it down to a couple paragraphs and give them the highlights of it and say, further details are in our HIPAA agreement or whatever. So they know there's more to it, but you're reminding them of their responsibilities under HIPAA and what they can and can't do. A nepotism policy, conflict of interest. You can also include things like your no weapons policy here, drug and alcohol policies can go here, but they can also go under the employee responsibility section. But start yourself thinking what you want to convey as serious legal kind of policies. And that's what I like to put in the general information, like upfront, these are things you need to know and you need to comply with because they're really important. And then I usually move on to employment policies, and you can start with the hiring process. If you have information about your applications in here, which is kind of weird because usually they don't get your handbook till they're employed, but sometimes they do. And one of the things you want them to know about the application is if they falsify any information, that you can fire them. I mean, and oh, and if you are at will, which I assume most of you are, you would put that under your first section, under the legal. It's not a required statement, but if you're at will, you want to tell them. And I realized I am not using my cheat sheet. I made a lot of notes, so let me just grab. Yeah, so I'm not missing anything I thought of yesterday. I don't think there's a lot in this initial. And I'll talk about drug and alcohol policy here because I put it in here. I'm sure that you, along with every other employer in the state of Michigan, has an issue with how do you deal with marijuana. And so it's still illegal under federal law. Most employers do not want people coming to work under the influence. I hate the term under the influence because if you have an issue, how do you prove what under the influence is? There's no way, there's no definition under any law, and it's a very difficult thing to prove. So what I suggest, how I suggest handling it usually is you prohibit illegal drugs, including specifically marijuana, regardless of whether you have a medical marijuana card or regardless of whether it's legal, it's prohibited under your policies. And you can say under the influence, but what I like to say is with you are prohibited from being at work with any in your system. And most of the time, you're not going to know. It's, you know, the problem with marijuana is it stays in the system a long time, but if they're coming to work and doing their job and you're not aware of it, so what? It's when you suspect there's an issue that you might have to send them for testing or take action, then you have the right to take action based on your policies because they have it in their system. You don't have to get into when they last used it, how much is in their system, how it affects them. You can just say, if it's in your system, you're in violation of our policy. And again, you're not going to be out there being the police every morning, but when you have an issue, it gives you a tool to handle it. And so that's the only way I've really found to address that issue. And the other thing is about testing, because that's what you can do. That's really the only way you can know, unless someone's reeking of it, or clearly has something going on while they're at work. But most employers don't want to be in the drug testing business. I mean, if you have DOT drivers, which wouldn't apply to you guys probably, they have to. But otherwise, I find most employers, it works to say that you reserve the right to test if you have a reasonable suspicion. And then again, reasonable suspicion, there are ways to define it, but it's just too vague a term. So just go with reasonable suspicion and then be reasonable in your application of that. You know, if someone smells like it, if they are glassy eyed, like they're just off in space, and you're going to know that this is not their normal demeanor. That's reasonable suspicion. I mean, your at-will employers, you prohibit it, so then you can do it, but you don't have to be, again, the drug police or testing everybody that comes through your door. Because you're private employers, you can test applicants. I find that with the legalization, that nobody tests because they wouldn't be able to hire anyone. So they just go with the reasonable suspicion and deal with it if they have to once it is a problem.
So if you have a staff person that has a medical marijuana card and you tell you, well, I need this, you know, for my back pain or glaucoma or whatever, you've already put in the handbook that it's regardless of your status.
So then you just say you can't be at work under the influence of it. And again, they would be subject to your reasonable suspicion, you know, and again, that's someone who, if you drug tested them, is probably going to turn up positive. But if they don't, if they use it on Friday night and come to work on Monday, they're probably going to be fine to do their job. But if they smoke it every morning before they come to work, that's a different thing. And that's probably going to show up in their ability to do their job. And so they don't have any right to be at work. They can have a medical marijuana card, but that protects them from getting criminally charged. It doesn't protect them at work. There's always been talk that, you know, maybe we should protect them at work, and there are movements in some states where there's a lot of protections, especially Colorado, and I think maybe New York, where employees have gotten extra protections at work for being at work under the influence. And in my opinion, that's a terrible thing to take away from employers, but that's not the case in Michigan and most states. So you can just say, well, that's okay. I mean, I'm just telling you, you can't be at work under the influence, so you'll have to figure it out.
So don't pound down the 5 gummies last night.
Right, yeah.
I've run into the same problem with prescription drug use.
Well, it'd be the same way with opioids. If you can't,
Exactly.
if you come under the influence on opioids and can't perform your duties.
Well, there's two things there. One is your policy should prohibit using prescription drugs other than as prescribed. You know, so people that have an addiction are taking more than they were prescribed, usually. And secondly, you put on them that if they are on medications that affect their ability to do their job, it's their responsibility to come to you and tell you that. And that, again, kind of arose out of the manufacturing setting, because they didn't want people running high-lows and working on lines that they could lose an arm or, you know, kill somebody driving into them or whatever. And so you put the responsibility on the employee to come to you if they're on medication that could impact their ability to do the job, because you, again, don't want to be the prescription police either and have people telling you things that you don't want to know unless you need to know it, because then you get into the whole ADA thing. Now you know they have a disability. So if they don't come to you and they do appear to have to be on something, whether it's legal or illegal, and it's affecting their ability to do their job, and they haven't told you that it's a prescription medication, then they're in violation of your policy. And if they do come to you and say, I have to take this prescription and I'm worried, it makes me sleepy, whatever, then you might have to get into the ADA accommodation issue, and accommodating them might be putting them off work until the prescription runs its course, or, you know, they might need to find out if there's another medication. It can get complicated, but if you have that in your policy, it gives you some teeth to work with.
So in my case, that was an employee that she didn't think it affected the ability for her to do her work, but the other staff members did.
Right, and so you can say, we have observed this, and this, and so regardless of what you think, we're running this place, and this is what we observe, and it's not acceptable. Yeah, I mean, that is a really, it's just so prevalent. The marijuana is prevalent. It's really something that we didn't need, I guess, to deal with in the employment arena. There's already enough issues out there. Yeah, so those are the biggies. Allow reasonable suspicion testing. It doesn't mean you're going to be out there drug testing everyone, but it gives you some teeth. Put prescription drugs as, you know, misuse of prescription drugs is prohibited. Marijuana is prohibited. None in your system rather than under the influence. And self-reporting of prescriptions that might impact ability to do work. And those are pretty much the biggies to have in your drug and alcohol policy. And then, you know, as far as ramifications, it's one of those things where you open yourself up to potential discrimination claims if you give yourself leeway. But almost every employer that I help with their drug and alcohol policy wants to give people a second chance if they've been a good employee and they've invested a lot of time in the employee. So it can go either way. You can have a hard and fast, if you're caught, you're out of here, or you can say, you'll be disciplined up to and including immediate termination, and then just leave yourself some opening for how you want to handle it if you actually have to handle it. So under employment policies, so we talked about, the hiring process. If you do background checks by third parties, you have to comply with the Fair Credit Reporting Act. So you would put that in your policy, just that you do comply with it, that you do require background checks. And one of the things to have on tied in with handbook are applications. And so you would want your application to have information that, you know, your drug policy is, they can't be at or with any in their system, and that you have reasonable suspicion testing. You would want your authorization for background checks to encompass throughout their employment, that you can run a check at any time. And so that allows you, under the Fair Credit Reporting Act, that authorization allows you to conduct an investigation during their employment. Say you get a sexual harassment complaint or an embezzlement complaint or something like that. If you go to a third party, even your attorney, anyone, you don't have to give them the Fair Credit Reporting Act notices and get their permission, because you got it initially on their application. And so it lets you do it privately until you have enough information to take action, and then you have to give those notices. But if you get those authorizations and make them more generic, covering their whole employment on the application, their whole course of employment on the application, it can be useful down the line. So, and also if you, and I'm kind of just going all over the place, but I'm thinking about it as I say it. Another thing to put on your application, if under the law for many claims, the feds are trying to eliminate it, but there's still a loophole. If employers want a shortened statute of limitations for most employment law claims, you can do that. The courts have upheld 180-day statute of limitations instead of the 3 years if the employee agrees to it. And so I put that on the acknowledgement page, and you can put that on your application also. So they're signing off before they ever take the job. They know that if they want to bring a claim, they have to do it in 180 days. So the application can have a lot of protections for you. And it's a good idea to review that every once in a while and update it to get some of those protections built in. So you would cover orientation period, trainings, things like that. Personnel records, not only what needs to be updated, you know, name, address, dependents, blah, 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 but also you should give them a short paragraph about their right to access their personnel records under the Michigan Bullard-Plewicki Right to Know, Employee Right to Know Act, so that if they want to see their employment personnel file, employment records, it tells them how to do it. They have to request it from whoever and the circumstances, or you could just say they're available if you request it from so-and-so, and then you can give them how it's going to happen when they actually request it. So that's usually a pretty short section, but it's more like, I guess I describe it as procedural things having to do with their employment. And then moving on to employee responsibilities, and this is where you address attendance policies, behavior policies, let's see. Yeah, like sometimes I use an anti-bullying policies. There are employers that have issues with that, and it's different than harassment or discrimination. And so it's my play nice in the sandbox policy, those kinds of things. Their work rules, your expectations, your attendance, your call-in policies, reporting work comp injuries, dress code. For medical practices, a lot of practices want put their licensing requirements, like it's up to you to keep up with your continuing education. It's up to you to renew your license. It's up to you to report to us and give us a copy of your license renewal if you have licensed nurses or employees. That would go under employee responsibility. So it's just thinking through those things that you expect your employees to do, and they may or may not think of it on their own. So you want to put it in your handbook. If you have a smoking policy, use of office equipment, computer use, cell phone use, a social media policy, and the social media policy, if you have them, make sure it includes the language from the Michigan Internet Privacy Act, and that says that if that employers are not allowed to ask to see employees' Facebook pages, ask them for their passwords. You can look at public spaces for information they have out there, but you cannot, you're prohibited by Michigan law from asking to see their private pages, even if it's reported to you that something's on it that you would want to know about. You cannot ask for that. You'd put your safety policies maybe here, a whistleblower policy, which encourages people, employees, not people, sorry, to bring their concerns to you before they report concerns outside of the practice that might, if somebody thinks you're breaking the law, if they think that you have billing discrepancies or things like that, instead of running to CMS or whoever they would report to, it encourages them to come to you first. You can't require it, but you can encourage it and get a chance to address any issues that may or may not be out there that you may or may not have known about before it gets outside the practice. So it's a good idea to have a policy encouraging that. If you have issues with whether closings or not closing, and you have a policy about how you handle that, that would go here. And so the pandemic obviously created a whole new closing policy, and I don't, and no, I've not seen any lawyers or HR organizations that encourage having a COVID-19 specific policy, but as a result of the closures and the safety measures and things like that, we've been creating generic infectious diseases / pandemic policies that give a basic outline of who's responsible if this happens, for coming up with a policy, for training people on it, the authority that they have, like developing the policy, requiring PPE, shutting the office, keeping people out, like just generic kinds of things, not just for COVID-19 and, but having some kind of policy in place that gives people an idea if we have a situation like this again, what more the framework of how a policy will be developed, because we don't know what the policy will be, what's required until it happens. But basics, that if the office needs to be closed, or if certain people are going to be sent to work remotely, which is a whole nother policy, that the office manager or the board of directors, president, whoever it is responsible for doing it, and they have the authority to do these things and anything else that might be needed. So I think it is a good idea to just put that out there, so you have a framework if you have to do that again, which hopefully we don't. And probably, all of you are covered by the OSHA ETS rules, right? The emergency temporary standard. Yeah. And so you already have COVID preparedness plans. Just keep updating that. But that doesn't really, I wouldn't recommend putting it in the handbook, because again, it's COVID specific and it's gonna be moot as soon as the pandemic is no longer considered a pandemic, and you don't want to rewrite your handbook every time there's a different disease or something. So keep that up, but I would just have that as a separate policy. And as an aside of that, almost every employer had to come up with something for a remote work policy. And that is something you can include in your handbook also, because that could be of use going forward. Again, it wouldn't be pandemic specific, but you could outline if you are required or allowed to work remotely, this is how we handle remote work. It wouldn't be tied to the pandemic. It would just be a remote work policy that certain positions are able to do their work from home. This is our expectation. We provide equipment, you provide equipment. You keep accurate tracking of your time. You work from blah, 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 or in the alternative, you can work anytime you want, but get your work done, whatever it is. Like, so think through your remote work, do a policy, and that probably should go in your handbook, but also do that as an agreement, like have them sign a separate document as an agreement that they're agreeing to the terms if you're allowing them to work remotely, because then it has teeth to enforce. So following employee responsibilities, hours and pay procedure, those are pretty basic. Employee classifications, and make sure you include exempt and non-exempt definitions, as well as full and part-time, seasonal, whatever you might have as work categories. Work schedules, working hours, timekeeping expectations, how they do it, how often they do it. Your 7 consecutive 24-hour periods for the Fair Labor Standards Act work week should be identified in your handbook. Information regarding paydays and receipt of paychecks. And if you do, many employers require direct deposit. If you do that, make sure that you have the language in your policy that allows them to get a debit card if they don't want direct deposit, because in this day and age, it's kind of crazy, but there are people without bank accounts. And so the Michigan statute that allows employers to require direct deposit also requires employers to offer an alternative. And I cannot think of the name of it right now, but if any of you need it, one of my clients gave me the name of a company that does the debit cards, handles the debit cards, and I don't even think it costs anything. It's not like a payroll company or anything. And they just provided her with them up front. And so So when she had a new hire that didn't want to do direct deposit, she could hand them the card right then, and I could get my hands on that. I just don't, I don't know what it is right now, but if you need that info. Under hours and pay, you should have a salary basis policy, which only applies to exempt employees. But exempt employees have to be paid on a salary basis, which I think you all know, it's a term of art. They can't lose pay if they're not working. You can't deduct from their pay. But the purpose of the salary basis policy is to protect you if you inadvertently deduct time. Say somebody is out of PTO, an exempt employee, they take time off for less than a full day, and you don't pay them for the time that they were off. You can't do that and still keep them as an exempt employee. But under the salary basis policy, it says if you think that we wrongfully deducted pay from your salary, you come to us and tell us that, and we'll look into it and correct it. And if you do that and they don't come to you, then you're not going to be held liable because, or probably won't, because it was on them to report it and you didn't catch it, they didn't catch it. And again, if they report it to the Department of Labor and they see you have this policy, you're good, because it's called the safe harbor. And if you have the policy, you can take advantage of the safe harbor and they don't lose their exempt status just because there was an error made. So push it off on the employee to report it to you, and it's a protection for the employer. If you have an expense reimbursement policy, it would go under hours of pay procedures, explain payroll deductions, overtime, garnishments. You can put performance evaluations here, just how often you do them. If you have a break policy, if you have a no call, no show policy. And I recommend that you do have a no call, no show for 3-day policy, because under Michigan law, it will disqualify them from unemployment. It's actually, it's got to be 3 days, but if you, and you have to have a policy, but if you do, it will be a disqual. I mean, they should be anyway, but there's actually a rule that says that. So you want to do that. And sort of as an aside on the unemployment issue, Michigan has determined that employees who are fired for failing drug tests for marijuana are still entitled to unemployment benefits. Just, yeah, that's a real winner. Then benefit policies, you know, explain your insurance, vacations, time off, jury duty, and a consideration that you may or may not want to put in your handbook. It's about 50-50, but just know that exempt employees can't be, they have to be paid for the time they're on jury duty. You don't have to pay your hourly employees for serving jury duty, but exempt can't have their pay back for jury duty. Family Medical Leave Act would go here if you're subject to it. You're probably not for most of you. And the same with the Paid Medical Leave Act. But I recommend, if you are not subject to the Family and Medical Leave Act, to have a policy that's non-FMLA medical leave, because I've never met an employer who didn't have to deal with employees who need medical leave. And so be proactive in thinking about how you would handle it so that you don't discriminate. Like, this is the guidelines of when you're entitled to it. This is how much you get. And you can use the parts of the Family and Medical Leave Act that you like and not use the parts that you don't. For instance, you can or cannot, you're not bound by it. So unless you have 50 or more employees. So you can say you can take up to 60 days of medical leave. We require a certification. We are or are not going to continue your healthcare benefits. You might have them COBRA it if you're subject to COBRA. You might continue it for a period of time or not. You might make them pay the whole cost. You can say, we'll try to return you to your job at the end of your medical leave, but we can't guarantee it, which, under family medical leave. So you can go through and twist it to work for you without subjecting yourself to the Family Medical Leave Act. So you just call it a non-FMLA medical leave. And it works for a lot of employers because then they have a non-discriminatory policy to look to, and employees know what they can and can't do, and the employer knows what they can and can't do. You should have a section telling them that you comply with USERA, the military leave law, and you don't have to give a big explanation, but just tell them that if they need military leave, they need to give you their orders as soon as possible, and you honor the law. If you have any other type of unpaid leave, you put it here. 401ks, IRA information, just again, and always refer just the benefit plans take precedence over what's in the handbook. If you have 20 or more employees, you're subject to COBRA. I don't know if that's applicable to any of you, but if it is, you should have an explicit COBRA policy, because most employers don't know. If you're subject to COBRA, you are supposed to give all the COBRA notices that are at the end, or when the person goes on COBRA. Those are also supposed to be given to the employee when they become eligible for your group health plan. And most employers don't know that and don't do it. They just have the COBRA administrator or whoever give it when a person applies, but it's actually also supposed to be given at the time that they go on the group health plan. So if you put it in the handbook, everyone's going to get it. And so you cover yourself for that. Do you have a question?
No, I'm
Oh,
trying to explain something to Jamie, sorry.
okay. You can put a paragraph on unemployment, social security, work comp, which technically are, I guess, employee benefits. Then if you have safety policies, general rules regarding safety, reporting work-related injuries or illnesses immediately, what to do in cases of emergency, biohazards if they're potential to be exposed. And then finally, changes to employment status. You cover resignation and termination here, what happens. Make sure if you have a vacation policy, it says either that you do or do not pay when people leave, because if it's silent, it's just a mess. Michigan, neither federal or state law requires you to pay out. They don't even require you to have benefits. With respect to benefits, Michigan law will require you to do whatever you, oh my goodness. Maybe I need a little more coffee. Require you to do whatever you say you're going to do in writing. So if it's in writing, you have to do it. So you could be silent on it. You don't have to pay it if you are, but it's just better to put it in writing. And you can say, we're not going to pay it out when you leave. You can say we are going to, but if you leave in good standing as determined by us. So in those situations where somebody's got accrued time and they're leaving, but you either fired them or whatever, then you don't have to. But generic leaving in good standing leaves you a little leeway to determine that, who you're going to pay and not. Exit interviews are a good idea because you can find out sometimes things that you didn't know were going on. It might not save that employee, but it might help you going forward. It also helps, put in it that they have to give you everything back at the time of the exit interview. You cannot say, we're not giving you your last paycheck until you return everything. You can sue them, but you can't withhold pay. If you owe, but you could, if you pay out vacation benefits and they have accrued vacation, you can withhold that because that is not pay for hours worked. So that's one avenue that you can take, that you don't give them that until they give you back equipment or whatever it is that they have. But if it's pay for hours worked. You can't withhold it, and don't put it in your handbook because that would be a huge red flag if a government agency came in. Job references, I throw this in here because a lot of employers, I don't know, it's a lot of employers, but it lands on my desk, so they have to call a lawyer when it happens, so it's a bad thing. You don't want employees giving good references for their buddies who've been fired for sometimes really egregious things. So you have a policy that says only the practice administrator or the HR person or whoever is allowed to give out references. So any calls you might get must be referred to the point person. And you don't necessarily have control over it, but at least it won't be a reflection on the practice if they're giving out bad references or good references for bad employees, and it comes back to you and you're like, I didn't know anything about it. And we have a policy that says they have to send it to me. So then you can take action against the violator employee. So policies to consider under COVID, I've touched on this, but so mandatory vaccination, mandatory testing, masks, you're all, I don't know how many employers, I mean, there's going to be employers up here who are covered, but that 100 employee mark is pretty high for mandatory vaccinations. I don't know, did Munson require it?
There weren't.
Yeah.
But it says all healthcare also.
Yeah, I think that all healthcare, I haven't, well, first of all, nothing is out there yet. And they're saying that Biden kind of blindsided the agencies. And so they think it's going to be several weeks. And frankly, OSHA is encouraging employers to just get their policies in place now anyway, because the wheels of government are going to take a little longer than anyone wants. So you can and always have been able to mandate vaccinations, flu shots, things like that. It's the same thing, really, except for the politicization of this issue. But the only exception, you probably already know this, is for religious, bona fide religious exemption and medical. And those just have to be dealt with on an individual basis. And you probably already have dealt with them by this point. Do any of you mandate vaccinations?
Yeah.
Yeah.
Or not.
We have can you hear me?
Yes.
We have a mandatory flu vaccination policy, but we do allow our employees to sign an opt-out, and then they're required to wear masks, which we're all doing anyway.
Right, and I think that that's how most healthcare practices have handled it, and especially that's about the only way. I mean, unless someone has a job where they can work remote, you can keep them out of the workplace, like maybe if you have a biller or someone, but other than masking and socially distancing, and I've had healthcare settings where the employer, diligently enforces from the time in the door to the time out the door, you have to wear the mask. You have to go outside to have meal breaks because you can't have your mask off on property. And that gets old for people. So if they're just holding out, either they leave or they wear it.
So you can have a policy that non-vaccinated people have to go elsewhere to eat?
Yeah, it's a
It
safety
seems like
thing.
it seems like some sort of discrimination policy
Right.
to me.
It also feels to me like we're gonna face an even higher shortage of employees
That's a problem.
because people are gonna opt out.
Well, that's a problem, but that's where honestly, the federal mandates are good because they're not gonna be able to go down the street and have different rules. That, you know, everyone needs employees, but everyone's gonna have to follow the same rules. You know, even in the schools right now, the kids that are showing up and not wearing masks are being segregated. They can't go in the lunchroom. They can't go in the classroom. They're putting them all in one room. So it's not, you know, vaccination status isn't a protected category, basically. I
Good to
guess
know.
if it's for a medical exemption, I don't know, I haven't addressed that. I guess that could be, if they have an exemption, I guess that could be a problem to make them go outside, but I do think you could segregate them from the lunchroom, like make them eat in their office or, you know, because you're trying to stop the spread of a disease.
Mhm.
They'd be hard pressed to prove they were being discriminated against when you could prove there were health reasons for doing it. Because to eat, they have to take their mask off, which exposes people. And they get exposed, frankly. I mean, yeah, we're waiting on the rules. You guys are kind of already dealing with them, although the vaccination thing's gonna be big. But again, with the feds requiring it, everyone's gonna be in the same boat. So all these people who are gonna quit and go next door are gonna be told the same thing. So there might be a revolving door, but it's probably going to come back around. There's probably gonna be this big circle of people going next door, and yours are going next door there. It's gonna be,
Well, they can go next door as long as the employer doesn't have any folks, right? And they're not. a healthcare-
well, if they're not healthcare, right? But I think that, I don't know, it is going to impact people. There will be some at that. There are going to be private businesses smaller than 100 that don't adopt it, but I think a lot of people are going to adopt it. I think people are fed up with having this out there. I really do. I think that employers are worried about having to close down again. The Delta variant is rampant up here. I'm in Emmett County and we just hit 70% vaccination. So that is really huge, but people are still people are wearing masks. You go to Meyer, everyone, not everyone, but I'd say 80% of people have masks on. They're wearing them even though it's not required. And we have such a big tourist population, just like you do. And people don't want to deal with it. So they're wearing their masks. They want people to get vaccinated. They're getting vaccinated. And I think a lot of it's peer pressure too. And I think that's what it's going to come down to. So we've talked about a little bit about the emergency temporary standard. OSHA is going to be writing the same kind of policy, and we believe it's going to mimic the one that's already out there for healthcare practices for all the employers they have to write it for. And my OSHA just did a Me Too. You have to do whatever OSHA says, and so they will again probably adopt that. And so stay tuned to any changes my OSHA may make, but they're giving a lot of signals, OSHA may make, they're giving a lot of signals that they're basically going to work with what they've already got out there and just broaden who it applies to. And again, you guys are already covered, except for the mandatory vaccinations and testing. An issue that's going to arise and has not been addressed is who pays for testing. If you have employees that aren't vaccinated and you require testing, you can require them to pay for it. That might change when we see these rules, but right now, I've got some municipalities downstate that put in mandatory vaccination requirements a while ago, and they require weekly testing if you refuse, and regardless of whether you have an exemption. But if you just let, for those people and for people who just refuse to get a vaccination, they are charging them the $200 a month that Delta came up with for their health care. So those employees have to get weekly testing they pay for, and they have to pay $200 a month extra for their health care. So those are measures you're going to see that, again, the fed up factor, like, just do this. And those are all okay. But again, the testing, paying for testing might change with these rules, but right now you can charge them for the testing. And if they get results, if you require them to provide the results, which you're probably going to if you're requiring testing, that would just go in their medical file. So we talked about an infectious disease pandemic, communicable disease policy. Don't be COVID-19 specific, just generic. If any of these situations happen, how it's going to work. So if you have to do a remote work policy, if you don't already have one, it should be in writing. It should be in your handbook, but again, also have them sign a separate agreement. Under Michigan law, the courts have been whittling away at some of these agreements that employers have been including in their handbooks. So if it's something that you want to bind someone to, you can talk about it in your handbook, but then have a separate document, not consecutively numbered, not an appendix, not an exhibit, not an attachment to the handbook, totally separate document that covers if you want arbitration, if you have a non-solicitation clause, if you have a non-compete. Usually, most of my medical practices have separate HIPAA agreements they make people sign so that they're bound by that. If you want a shortened statute of limitations, that needs to be, and it could all, most of them can even be in one document, but it just has to be separate from the handbook with their signature on it so that it's enforceable, because the handbook always says, you know, these policies are subject to change. This isn't a contract. And so the courts have said, well, if it's not a contract on your side, then it's not a contract on their side. So you need the separate document that's the contract of what they're agreeing to. And so remote work, same thing. You want them bound by your policies and that they're going to follow them. So have a separate agreement that they sign. You should, if you're going to do remote work, you need to analyze every single position or classification in your workplace and determine what can be done from home and what absolutely can't. Like you know, I guess telehealth could be done from home. I don't know, but mostly seeing patients, that's going to be done in the office, but a biller or someone probably can work remotely. So attach not by person, but by job or classification, you have your own cheat sheet on what you've determined. And if you've determined it can't be done remotely, that have notes as to why, like have your, so you don't get in a situation where you're being accused of discriminating by person, where it's really a job determination, but it happens to be a person who desperately wants to work remotely and they think they're being picked on. Outline the expectations you have for people who do work remotely, like they're not babysitting their kids or their grandkids while they're working remotely, that they're actually working, that they're logged onto the computer during the hours you want them logged on, things like that. Make sure that you enforce accurate timekeeping for non-exempt employees, because you don't want them, oh, their computer's handy, I'll just check my office email after I put the kids to bed, things like that. That's compensable time if they're non-exempt. So have very strict timekeeping rules and enforce them, that they have to report their time accurately, that they're not allowed to work after 5 o'clock or whatever it is, not allowed to log on. Not allowed to work more than 8 hours in a day, 40 hours in a week, whatever your rules are, that would be in the office, put that in your remote work policy, however it works best for you. And as part of your remote work, and any handbook review, you make sure that your computer use policy and your electronic equipment policy has your security requirements. They, everyone's found out from having to send everybody home that they might have loopholes in their security, and especially when you're HIPAA, you have all your HIPAA requirements. You need to figure that out with your IT provider, and then you need to give explicit instructions or expectations in your remote work policy and in your handbook under your electronic equipment policies. And it could be anything from you have to work in a private area so people don't have access to look over your shoulder and look at, so they're not at Starbucks bringing up medical records or something. Think out of the box. That's something you need to consider, that when they're in the office, it's not as much of a worry because most people would have authority to see what they're seeing, or they aren't even concerned about it. But when they're out of the office, you need to have some checks and balances in there and some, outline for people the do's and don'ts. Okay. So diversity and inclusion is just becoming the topic of the year and going forward. So, we all live in an area where that's a little hard to do in some respects, but you have the sexual orientation issues, women, of course, minorities. And so it's a good idea, again, if the EEOC comes knocking, to have a policy just acknowledging that you are inclusive and you have a goal to, be diverse and include people going forward. You expect everyone to be respectful in the workplace, and it doesn't have to be elaborate, but something to show that you adhere to it or intend to. It doesn't have to say, like, I've seen policies where they're like, okay, we're going to post this and we have to have this many candidates and we have to interview this many minorities. And I'm like, well, who could follow this? Like, this is silly. Just have a policy that's welcoming and encouraging people to play nice in the sandbox under the label of diversity and inclusion. And it will go a long way if you ever get, an investigation or the government comes knocking on your door, or you have complaints in the office from coworkers, and you can point to the policy, play nice in the sandbox. Everybody's going to get along. Like, everyone has a right to be here, and just gives you something to point to and to strive for. So Jamie said the one question she got ahead of time was what to do about tattoos. And so I ran this by, there's kind of like 4 people in our firm that we all have similar practices, and one of them's in Ohio and a couple are in the Detroit area, and I'm up here, and I'm like, okay, so how do you guys handle this? And 2 of them shot back, what do you mean? My clients don't even care. Like, okay, well, there are people up here that care. And so the only really useful suggestion, I mean, you can require they be covered, but in the situation that was presented was, what if they're not coverable? And I'm assuming it's like face or
neck.
They suggested requiring Band-Aids, which I thought was creative.
They would be a full Band-Aid.
Yeah, someone said,
Indiana.
they're gonna, one of my colleagues said, yeah, they're gonna look like they mess with Jack the Ripper probably. So I don't know, I guess neck, you could require like a scarf or something, and if it's on the face, a Band-Aid, I don't know.
I think it just needs to be removed at this point.
Well, that would be good, but I mean, if you make them covered, again, it's one of those things where that gets old. if you're going through a box of Band-Aids every morning and then ripping it off at night.
Yeah, no, I mean, remove it from the policy handbook. I mean,
Oh.
75% of my employees have tattoos, so I'm not sure why we have it in our handbook at this point, because it's,
Yeah, I think we have to, move with the times.
yeah.
You know,
Yeah, I mean, again, I don't, the reaction was, I don't put it in my handbooks that I do generally unless someone asks for it. And my colleagues were like, what do you mean? None of my employers have that. They don't care anymore.
Well, I think in the past, you know, in a medical practice,
Oh.
we used to be very conservative and people had to, you know, we would have never thought of hiring somebody with a nose ring and purple hair. I'm sorry, but that's what today's 20-something is. And every female I've seen practically. And
Yeah,
if I want to,
if you want to
you know,
fill your jobs.
and I want diversity and I want young people and all of those other things, I'm gonna have to have pink-haired, nose-ringed, tattooed young people in my practice. And I mean, it's the reality.
When you have the upper hand, you can enforce some of those a little better. And like the nose rings, you can say you can't wear it at work. I have a little sideline. I'm a part owner of some restaurants, and we prohibit tongue piercings because it just seems not to go with restaurant work.
Although
But,
it works right now with the mask.
Right.
well, yeah, yeah, it's still mind-boggling, but
What about wording, about jewelry or tattoos or whatever being tasteful or respectful?
well, sometimes I see you're limited to 2 earrings per ear or something. I've got language, I don't know off the top of my head. Professional is usually the word that's used, I would say. And again, that's open to interpretation, but yeah, especially with the purple hair, and, you know, I mean, that clearly wasn't professional. I don't know what is professional now, but you can limit, especially in a medical practice, a lot of medical practices limit jewelry to, you know, a watch, a couple earrings. No, I mean, I guess you could even say no bling, but that probably gets bad connotation. But, you know, a simple necklace or something, or not even that, you know, you just don't need it at work. So that kind of is generic because there's many males out there with ear piercings and bling as women. And so, you know, if you don't need it, leave it home. That's kind of hair. You can require, you can't prohibit, like there's religious exemptions for policies. So if someone, you know, Orthodox Jews have their long locks, you can say that hair has to be neatly pulled back. That's generic. If guys have long hair, they have to pull it back. Women have to pull it back. Or you can, well, we used to write policies about men having to have collar length hair. I don't think you could get away with that now. But if someone comes to you like facial hair, you used to be able to prohibit that. And if you had a legitimate reason for doing that, like sterile reasons or something like that, I think you still could, but then there'd be a religious exemption that would apply to some people.
I think, with the facial hair, that was an issue at the hospital with, the N95 masks.
Correct, and it's an issue with firefighters because their oxygen masks don't fit correctly. Their respirators, whatever they wear, don't fit correctly, and that's where most of the cases come from. And so you can, if there's a legitimate job-related reason, you can have policies about that, but it always you just always have to think, you know, is somebody going to claim to be discriminated against? But if you can point to a legitimate job qualification, or essential function, then you're gonna be okay doing that. Anything else in here?
Hey, Laura, I have another question that, I didn't see anywhere where, smoking policies were addressed. And I've had something crop up in my office where I actually have somebody who uses,
The vape.
a vapor, whatever thing. And I've put in my policy, no tobacco use, no, no smoking of any kind, including the use of e-cigarettes or whatever they're called. And I catch her periodically.
Then she's in violation. You can, I don't know if I have e-cigarettes, but I put no vaping. Yeah, you can prohibit any of that, and then she's in violation. If you have a smoking area at the back of your parking lot, or you tell people they can go smoke in their cars and that's the only place they can smoke, you can require that for the vaping too.
So when you make small changes to your handbook, like something like that, then everyone has to get a copy of the new handbook and a new acknowledgement of the handbook.
Yeah, you can have your handbook online too, if people all have access to it. But otherwise, if you do, well, there's a couple different ways to handle it. One, you should have something, it's a best practice, and I don't know that many employers that do it. Ours does. I get one every year and they hound you till you turn it back. They make you sign a new acknowledgement every year. They'd say, we changed policies online. Here's the ones we changed. Return this to HR by the end of the month or else. And I don't know what the or else is, because I don't usually return it really quickly, but you can do it that way and just identify what you changed. If you make a major change, like you add a remote work policy, you add significant policies like your sexual harassment, things like that. And I use a no harassment policy, not just sexual, because as an employer, you should know that probably most harassment is not really prohibited. It's not a good idea, but sexual harassment is the big one that's really protected by law and racial. But I just cover them all anyway, and it discourages people. And if they do it, they're in violation of your policy, even if it's not a violation of law. So you say on the basis of any protected protected category, we prohibit harassment. And another thing to think about in your harassment policies is to put in a specific mechanism for reporting, which everyone probably has. You can go to A, B, or C because you have to give them options. But put a time frame in there, like within 7 days of it happening, and also include they have to report if they feel like they're being retaliated against for reporting someone or participating in an investigation, something like that, and put a time frame for reporting retaliation. Because then if the employees don't report harassment or retaliation until they're being disciplined for something else, which is usually how it happens, then they come out with, oh yeah, well, this happened to me and we didn't do anything. Then it's on them to explain why they didn't report it in the timeframes that were in your policy. And so again, it's a protection. It pushes the burden back on the employee because they didn't follow the policy. And if they do follow it and report it, then you can investigate it. Well, it's fresh and people have memories and people know what you're talking about. So it's a good protection either way, whether it's occurring or not occurring. I don't even know, are we running over time here?
2 minutes.
Sorry.
I don't see any questions in the chat box. Does anyone have any questions for Laura today?
One other thing that you might want to be aware of, I don't know how big an issue this is going to be, but the background checking companies are freaked out about it. The Michigan Supreme Court issued an order, and it was supposed to take effect July 1st, and now it's delayed to January 1st, but apparently when people request court records going forward, after this order takes effect, all birth dates are going to have to be redacted. So like if you hire someone to run a background check and there's 25 John Smiths in the criminal court records at Grand Traverse County, they're not going to be able to match birth dates to court records. So just that, I just throw that out there so you're aware. Well, I think it's to prevent identity theft. It's not geared to background checkers because anyone can go in and request a copy of a public court record. And so it's really to protect identity theft, but it has that's why they delayed it, because I think they're trying to figure out how to rework the order to cover what they want to do and not interfere with that. But it's out there, just so you know, if you use background checks and check court records, you know, they're going to be names that are, you're going to know it's the right person, but there are probably going to be a fair amount that there are other people with the same name and you don't necessarily, an address might match and that might do it, but that's out there. So make sure your applications are up to date, your handbooks are up to date. One other thing that people may or may not know, since the last time we probably talked about this, is Michigan passed a law that prohibits employers from asking about misdemeanor arrest records. You can ask about misdemeanor convictions, felony arrests, and felony convictions, but you can't ask about misdemeanor arrests, if anyone's even doing that. Some people do, some people don't, but just be advised, we actually have a law prohibiting it in Michigan.
There is a question on chat, and if an exempt employee doesn't have any PTO and they don't work a whole day, please confirm we cannot pay them for that day.
No, if they work any part of a day, they have to be paid, even if they don't have PTO. So you don't, like, there are people who manipulate the system and like say, need chemo or something, and they come in for every morning and take every afternoon off or something. If they don't come in at all that day, you don't have to pay them. But if they come in half days, you do have to pay them the whole time. And you can force them to use PTO, and that's probably a bad example because there are some exceptions for medical issues, but generally, if they work any part of the day, and that's the same with at home. So your remote work policy for exempt employees might be they either have to take a whole day off or work a whole day or something, because if they take a day off for their own reasons, you can force them to use PTO and you don't have to pay them. I don't want to say that, but if the general rule is if they work any part of the day, they have to be paid for the whole day. And if they have PTO, you can make them use it, but if they don't, you still have to pay them.
Okay. So I have some non-exempt employees in supervisory type roles, and so they'll get call-ins and things. So their morning could start at 6:30. They need to, how should they be reporting, like a 15-minute chunk of time?
Yeah, however you time keep, whether it's, you know, 1/10 of an hour, 1/4 of an hour.
Okay.
They should log that time.
Okay.
Because it's compensable time.
Yeah. Gotcha. Thanks. All right, I don't see any other questions in chat. The password for the CEU certificate is listed in chat for those who are on the Zoom meeting today. Thank you, Laura, for providing this really valuable information again this year and coming all the way up here to see us. And thank you to everyone who participated in the call today. It will be available on the PAHCOM website, and I will go ahead and upload the slides to the library as Karen suggested. Thank you so much and have a wonderful day.
Thanks, you guys.
Thank you.